Hello, my name is Rachel Widdis. I'm the Director of EMEA for Article 1, a specialised consultancy with expertise in business and human rights, responsible innovation and sustainability. I also teach business and human rights on the Masters in Law at Trinity College in Dublin, and I'm delighted to give this overview presentation today on emerging regulation for the IHRB Global Forum on Responsible Participation. I'd like to talk first about some of the concepts, but especially the direction of travel and its acceleration. So, we see from left to right on this infographic that we have moved from activism to norms with the UN Guiding Principles on Business and Human Rights and towards hard law. So, we see this move to mandatory requirements focusing on reporting, disclosure, and also one issue regulations such as the UK Modern Slavery Act. And as we move further to the right, we see more regulation focused on increasing scope and complexity of human rights and environmental due diligence requirements, including in national states such as the Norwegian and also the German Supply Chains Act of 2021, and of course the future proposed EU Corporate Sustainability Due Diligence Directive, which we will talk a bit about today. So, these key trends, as I said, are towards hard law and increased transparency and accountability. But of course, large global corporations are familiar with these well established international frameworks, such as the UN Guiding Principles on Business and Human Rights and the OECD Guidelines for Multinational Enterprises. The issue is that the implementation of the responsibility of business to respect human rights in the UNGPs is voluntary. So, new regulation builds upon these widely accepted standards broadly, with one major difference: obligation. So, we have moved from a scenario where UNGP content is becoming an obligation, particularly in the EU. The key trends are a focus on risk beyond the entity regarding potential or actual adverse impacts on people, community, and planet, and also assessing the effectiveness of measures undertaken by business and measures of accountability via sanctions and, in some cases, civil liability. So, a paradigm shift has occurred and is needed, including in legislation and the proposed EU Corporate Sustainability Due Diligence Directive, or CSDDD, because the soft law standards were simply not implemented. There was not enough progress and no effective remedy. As Didier Reynders, the Commissioner for Justice for the EU, stated on launching the proposed directive, we can no longer turn a blind eye on what happens down our value chains. So, what is due diligence? Well, broadly, it applies to the company's own operations, subsidiaries, and their supply or value chains. In the case of the EU CSDDD, in their value chain for direct and indirect established business relationships, to identify, assess, and address potential and actual impacts on human rights and environment, and to report out on their effectiveness of the measures taken. So, to identify and address and to report out, what might that include? Well, to identify actual or potential adverse impacts on human rights and environment, and to identify, in the case of the EU CSDDD, established business relationships, to have a due diligence policy in place to be updated annually at least, and to integrate due diligence into policies, to address, to prevent potential adverse impacts or to mitigate where prevention is not possible, to bring to an end or minimize actual adverse impacts, including to compensate, and to publicly communicate on due diligence and monitor the effectiveness of policy and measures taken, and to continuously revise and adapt. So, this might include, for example, in order to operationalize, to really identify salient risks to rights holders across commodities, geographies, products. And it might look something like this: a heat map based on certain indices and identification of salient risks. We also see an evolution in the content of laws in terms of the normative standards that they refer to and also scope. So, as we move from the Norwegian Act across to the German Act and to the proposed EU CSDDD, we see that there are more human rights conventions and the addition, for example, of environment. The German Act refers to three specific conventions. These become wider as we move to the EU CSDDD, which also includes, as I mentioned, the value chain for established business relationships, direct or indirect. For the EU CSDDD, it is an obligation of means, and we'll talk a little bit about that more in a moment. So, this new legislation, and particularly the proposed directive, is more ambitious than existing due diligence laws and notably recognises that human rights and environmental harms are interlinked. It provides in its annexes a list of human rights and instruments, and the same for environment. It also includes a director's duty of care for directors of EU companies, such that directors acting in the interests of the company would have to consider the human rights, climate, and environmental consequences of their decisions through to the long term. I would mention, of course, that this is a proposal, it is not the final version, and it is currently within the EU lawmaking process. However, the inclusion of non EU companies within the scope of the directive is vital for acceptance and for a level playing field. To mention a few other matters, I talked about the obligation of means. So the EU CSDDD would not require companies to guarantee in all circumstances that adverse impacts will never occur or they will be stopped. It requires them to take appropriate measures. And to note also that other countries outside the EU, such as Japan and Thailand, are working towards due diligence laws. And this is crucial so that there isn't a disconnect between what is happening in Europe in terms of legislation and the effects on the ground in sourcing countries. Thank you.